Good afternoon, everyone. I hope that lots of people have been able to join. We can see the numbers ticking up in the corner. So thank you so much for deciding to attend our little webinar this evening. My name's Eleanor Wheeler and Krishma Patel sits on my left. And this afternoon, we are going to give you a whistle-stop tour through litigation involving children and protected parties. It's quite a high-level practical guide. We're not going into deep, dark case law on things. We're keeping it quite light. So if you're really looking for some academic commentary, this is not the place. We're just hoping to give people a good, useful steer through these types of claims. Bit of a disclaimer before we get underway. Please don't treat this as legal advice. We're just giving general guidance based on our professional experience of how these cases run, but please don't rely on this as legal advice from us to you. And finally, an email containing this recording and the slides you're about to see, and a feedback form will be sent over the next few days. So keep an eye out for that in your inboxes and feel free to peruse at your leisure. Alternatively, the recording will also be available on our website and YouTube channel. So feel free to look at them there as well. Okay, I think time to get underway. So some definitions quickly, first of all, not a particularly scintillating slide, but important to know what we're talking about. Children are people under 18, very straightforward. Protected parties are people who lack capacity, and I'm going to run through what capacity means in a moment. A child can be a protected party, not necessarily. And then a protected beneficiary is a protected party who also lacks capacity to manage money recovered on their behalf. So some people will be found to lack capacity to conduct proceedings, but will be found to have the capability to manage their own money. So they won't be a protected beneficiary, they'll only be a protected party. If you're both, then there are extra safeguards in place for those individuals. And then finally, a litigation friend, someone appointed to conduct proceedings on behalf of a child or protected party, and we're going to look at litigation friends in more detail in a moment. So, capacity. We're not going to be able to go into too much detail on this, but in summary form, there are 6 guiding principles which dictate the way that people must act under the Mental Capacity Act 2005, Section 1. And those are: capacity is assumed until proven otherwise, and that's an important point to bear in mind. Those 6 guiding principles: first, capacity is assumed. Second, a person is not to be treated as unable to make a decision unless all practicable steps have been taken to help them do so, and those steps have been unsuccessful. The third principle is that someone is not to be treated as unable to make a decision just because they make an unwise decision. The next principle is that somebody acting on behalf of an individual without capacity must act in their best interests. And the last principle is that before any decision is made, you have to consider whether the aim can be achieved in a less restrictive way to the person's rights. The definition of capacity is set out in Section 2.1 of the Mental Capacity Act.
And it's as follows: if at the material time he or she is unable to make a decision for themselves in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain.
Now, that's the statutory test, but of course, there's always going to be a formula or factors to apply to work out whether that test is met. And those factors are set out in Section 3 of the Act. They can be summarised as follows. Can the person understand information relevant to the decision they have to make? And that includes understanding the consequences of making a decision either way or failing to make a decision. And it's important to remember that that is tailored to the specific person's circumstances. So if they need things to be explained in simple language, or if they need visual aids to understand information, that's taken into account. The second factor is whether the individual can retain information, even if only for a short period. The third factor is whether they can use and weigh the information as part of the decision-making process. And the last factor is whether they can communicate that decision to somebody else. If those factors are met, then the person has capacity, regardless of whether the decisions they're making are poor ones.
There are a couple of exceptions to the Act that don't apply to those that are under 16, for instance, if they lack capacity now and they're unlikely to regain it when they're over 18, or to prosecute acts of willful neglect.
Absolutely. So largely the Mental Capacity Act does only apply to those over 16, but with those two exceptions that Krishma's just covered. The test for capacity is established on the balance of probabilities, and the burden is on whoever's asserting that the person lacks capacity. And these are often quite complex issues, and the court will often need medical evidence to support the contention either way. The question is a binary one. So if somebody lacks capacity to conduct even one aspect of proceedings, they lack capacity for the entire thing. You can't have capacity for one part of the litigation and not for others. It's black and white.
It can also be temporary or permanent, and capacity should be judged at the time that the decision in question needs to be made. And it mustn't be based upon any assumptions about age or appearance or condition or even any aspect of behaviour, and that's set out in section 2(3).
So that's a very light overview of the legislation relating to capacity, and we're going to do a very similar thing in relation to the Court of Protection. The Court of Protection is a specialist court. It has its own rules and procedure. It's outside the scope of this talk because we're dealing with the way that the CPR, i.e. the civil procedural rules, deal with children and protected parties. But in short, the Court of Protection is on the same level as the High Court, and it has powers to make decisions about people's capacity, make declarations, decisions or orders on financial or welfare matters, appoint deputies to make decisions, and we'll be looking at deputies a little bit more in detail later on, deciding whether a lasting power of attorney or an enduring power of attorney is valid, and it also has the power to remove deputies or attorneys who aren't carrying out their duties.
Moving on now to the requirement for a litigation friend in proceedings by or against children or protected parties. This is set out in the section of the rules CPR 21.2 and 21.3. And effectively what those rules say is that a protected party must have a litigation friend to conduct proceedings on their behalf, unless the court makes an order permitting, and in respect of a child, unless the court makes an order permitting a child to conduct proceedings without a litigation friend must also conduct proceedings on a child's behalf. Now, normally, as I say, that rule sets out that a child normally should have a litigation friend, but the court may, pursuant to that rule, make an order permitting the child to conduct the proceedings, even if they've already got one. And Eleanor's now going to take you through what is the meaning of conducting proceedings on their behalf.
So that isn't actually explained or elaborated on in the rules themselves. Neither is the duty of a litigation friend. So we have to divine it from elsewhere. It is clear, though, that under Rule 21.43, subsections A and B, the litigation friend has to confirm that they can act fairly and competently they can fairly and competently conduct proceedings, and they have no interest adverse to that of the child or protected party. So although it's not officially set out as the duty, that is in effect what they have to be able to do. They have to take all measures that they see fit for the benefit of the child or the protected party. And in order to discharge their duty, they have to be across the papers, and under proper legal advice, they have to take all due steps to further the interests of the child or protected party. There's quite a bit of case law on this in the White Book if you're interested in looking at it, but for present purposes, that's the position in summary.
The rules also note that the official solicitor can act as litigation friend on behalf of a child or protected party where there is nobody else able and willing to do so. However, it is worth noting that the official solicitor does require that their liability for costs will be covered before they do in fact act, and that's set out in Rule 21.6 subsection 6. Just to also mention that the rules 21.16 and 7, they both set out how the party should actually be referred to within the title of proceedings, and that should be consistent in all court documents. A child may only be referred to as a protected party where they will not gain capacity when they are 18. But I would urge you to have a look at 21.1 subsection 6 and 7, because it gives you an example of exactly what it is in terms of how to set out the name correctly.
It's important to bear in mind that any steps taken in the litigation before there's a litigation friend in place has no effect unless the court orders otherwise. Effectively, all you can do is issue a claim, and then everything has to stop until a litigation friend, thanks so much, Sophie, until a litigation friend is appointed. You can't take any other steps without court permission until the litigation friend is appointed, except, of course, for applying for a litigation friend to be appointed if you need to do so.
Moving on to the next slide now, which is who may be a litigation friend without a court order. And this is set out within Rule CPR 21.4. Now, it's important to say that 21.4 doesn't apply if the court has appointed a person to be a litigation friend. And also, under 21.42, a deputy that's been appointed by the Court of Protection under the 2005 Act that we discussed earlier, with power to conduct proceedings on the protected party's behalf, is entitled to be the protected party's litigation friend in any proceedings to which the deputy's power extends. Now, in terms of Rule 21.43 as to what is actually required for a litigation friend, this rule says, as mentioned by Eleanor earlier, that a litigation friend, a person may act as a litigation friend if A, they can competently and fairly conduct proceedings on behalf of the child or protected party, have no adverse interest, and where the child or protected party is a claimant, they undertake to pay any costs that the claimant is ordered to pay, subject to any right to be repaid from the assets of the child or the protected party. Now, the requirement, again, just touching base on what Eleanor said, the requirement not to have an adverse interest is actually closely linked to the requirement that a litigation friend can fairly and competently conduct the proceedings. The litigation friend is required to act for the benefit of the relevant individual and to safeguard their interests. They must not be seen as having a conflict, but where the litigation friend has an interest in the litigation that is not adverse to the individual, they may be properly able to act as a litigation friend. And the relevant question to ask is whether that personal interest affects the litigation friend's ability to fairly and competently conduct proceedings. If they remain able to weigh up legal advice and make decisions in the individual's best interest, then they are still able to act as a litigation friend.
And although the consent of the litigation friend isn't expressly set out in the rules, it is a fundamental requirement of the appointment of a litigation friend. That comes from a case called Major and Kirishana. So that's one of the reasons why we file certificates of suitability, because that's one of the declarations therein, and we'll come on to talk about those certificates shortly.
Moving on to the next slide, which deals with the procedure to become a litigation friend without a court order. Now, if the court has not appointed a litigation friend, a person who wishes to act as a litigation friend must follow the procedure that's set out in CPR 21.5. A deputy, as I've said, that's appointed by the Court of Protection under the 2005 Act, their power may well extend in terms of being able to act as a litigation friend. If that situation does indeed apply, then such a deputy is not required to file a certificate of suitability, but they must file an official copy of the order of the Court of Protection which confers their power to act. Any other person that's wishing to act as a litigation friend has got to file a certificate of suitability, stating that they satisfy the conditions that are specified in Rule 21.43. Where the child or protected party is the claimant, the certificate of suitability must be filed with the claim form, and that's pursuant to Rule 21.53A. Now, in terms of the relevant form for the certificate of suitability, it's in practice form N235. The certificate itself must be verified by a statement of truth, and in the case of a protected party, it must also state the grounds of belief that the person that are based on in terms of explaining why the person is a protected party. If that belief is based upon an expert opinion, that any expert opinion should also be served with the certificate or separately thereafter. Where the child is, as I've said previously, but just to cover this bit off, where the child or protected party is a claimant, the certificate itself must also contain an undertaking to pay any costs which the child or the protected party might be ordered to pay, subject, again, to any right to be repaid from the assets of the child or the protected party.
So when it comes to what the court needs to see, the litigation friend, or in reality their solicitor, has to file a certificate of suitability and a certificate of service. That's in accordance with Rule 21.55. In the case of a protected party, there's no need to file any expert report that Krishma just referred to, setting out why the person lacks capacity, with the certificate of suitability, but it has to be served, just not necessarily at the same time. Rule 21.5 doesn't apply, should be borne in mind, if the court has already appointed someone to be the litigation friend, or if they've made an order that no litigation friend is needed for a child. A court order is required to appoint a new litigation friend in substitution for an existing one, and that comes from Rule 21.71C.
We're now going to look at becoming a litigation friend by order. Now, Rule 21.6 subsection 1 states that the general proposition that is that the court may make an order appointing a litigation friend. Upon application. Now, an application for a court order may be made by A, the person who wishes to be the litigation friend, or B, a party. The circumstances in which a claimant must make an application to the court or for an order appointing a litigation friend are set out in further detail in Rule 21.6 subsection 3. It is worth noting that generally a Part 20 claim is to be treated as if it were a claim for the purposes of the CPR, and that's in accordance with Rule 20.3 subsection 1. And that means that 21.63 applies in terms of the circumstances in which a claimant must make an application for a litigation friend, where a Part 20 claim is brought against a child or protected party.
So the court can either act under this part of its own initiative, and that's pursuant to Rule 21.331, or on application by the people who Krishma's already referred to. Where the official solicitor is going to act as a litigation friend, provision has to be made for their charges, expenses, or disbursements, repeated again, and that's in Rule 21.66. Rule 21.81 sets out who the application for a litigation friend has to be served on, and there's a specified list, so have a look at that.
Moving on to the court's powers to change a litigation friend. This is dealt with in Rule 21.7. Now, an application for an order under 21.7 must be supported by evidence. Insofar as the application concerns the appointment of a new litigation friend, that evidence will have to satisfy what's set out in Rule 21.43, which of course we've already been through. In terms of whom that application needs to be served upon, it's got to be served on every person in accordance with Rule 6.13 that the claim form must be served upon. So the application must be served upon. In addition to that, must also be served upon the person who is the current litigation friend or is purporting to act as a litigation friend at the time that the application is made. And the application must also be served on the person who is proposed to become the litigation friend if they are not the applicant. It should also be noted that Rule 21.8 doesn't actually require service on the other party, but I would suggest that thought does need to be given to whether or not the other party to litigation should be served with a copy of the application notice.
And it's worth bearing in mind that the court retains a wide discretion in this area, so they can appoint either the person who's nominated in the application or frankly any other person who satisfies the conditions set out at 21.43 that we've been over already. And although the court has a discretion on an application by a litigation friend to terminate the appointment of that litigation friend, that is a limited discretion. So if the conditions in 21.43 aren't any longer met, or the litigation friend doesn't consent to act, it takes exceptional circumstances for the court not to terminate the appointment. That's Major and Kirishana again, a leading case in this area. So if those criteria are satisfied, the court is inevitably going to take away that person as a litigation friend. The loss of a trial date or the fact that no one's been identified as a replacement aren't likely to constitute exceptional circumstances. So that's going to happen regardless of whether they've got no one else to replace them.
21.9 deals with a procedure where the appointment of a litigation friend ceases. And the rule applies whether the litigation friend has been acting under a court order or otherwise. When there is a child who is not a protected party that reaches the age of 18, the litigation friend's appointment ceases, pursuant to Rule 21.9. This is automatic and there isn't a court order that's required, but the party must serve a notice on the other parties in the proceedings stating that they have reached full age and stating that the litigation friend's appointment has ceased. And they must also give an address for service and state whether or not they intend to carry on with or continue to defend the proceedings. That notice must be signed by the party personally. Whether or not there is a child that having reached full age serves a notice, a litigation friend may, at any time after the child has reached full age, serve a notice on the other parties that the appointment has ceased. This was actually previously an express provision in Formal Practice Direction to Part 21, which has since been revoked. But of course, many of its provisions are now included in the rules, but this is implicit in Rule 21.9, subsection 6.
So in contrast to the position where a child reaches the age of 18, if we're dealing with a protected party and they either regain or acquire capacity to conduct the proceedings, the litigation friend appointment will continue until a court orders otherwise. That's specified by Rule 21.92. In practice, to do this, you make a Part 23 application. It's got to be supported by evidence. That's likely to be a medical report or an expert of some variety's report indicating that the person has regained capacity, plus a copy of any court of protection documentation like the order or declaration stating that they're permitted to act. And if the application is made by the protected party themselves, a statement whether or not they intend to carry on with or defend the proceedings themselves. The former protected party, once that application is made, has to serve notice on all parties stating that the litigation friend's appointment has come to an end. They have to give an address for service. They have to state whether or not they intend to carry on with the proceedings, as I've said. And unlike in the case of a child, this doesn't have to be signed personally by the party. It's best practice to do that, though, in reality. And then finally, Rule 21.96 exposes the child or the protected party who doesn't serve the notice required under 21.94 to an application for an order staying or striking out the claim or defence. So it's pretty serious. So what to include with the claim form? Now, court approval. Where a claim is made by or against a child or protected party, and it is worth bearing in mind that these rules apply both to claimants and defendants, no settlement is valid without approval of the court. That's the main overarching principle that underlines these rules, and that's 21.10.1. This is largely designed to protect children from themselves, from undersettling claims, and also from nasty or unskilled lawyers who would seek to settle claims quickly and cheaply. The approval is still needed where, in the very unfortunate circumstances that the child or protected party dies during the course of the litigation, you still have to get permission or sign off for any settlement. And approval is required even if it's only one issue in a case. So you can, for example, settle liability and the trial goes on to deal with quantum only. You still need court permission for that settlement on liability. So if you've agreed a settlement and all you need is that court approval under 21.10.1, you have to use the Part 8 procedure, so the less complicated, less formal procedure for easier claims. That's set out in Rule 21.10.2bi. The claim form has to include a request for approval of the settlement, should say it on the face of the claim form. That covers also any voluntary interim payments. You have to get approval for every single payment made to the claimant, whether it's a final or an interim payment. And you have to include a whole raft of evidence, which we'll have a look at in the next slide. So this used to be set out in both the rule and also the practice direction. Some of you might be aware that as of the 6th of April last year, the practice direction has been revoked and the rules have been amended slightly to include everything that used to be in the practice direction. So this is the new list of things that you have to include with the claim form or in the claim form. First of all, a draft consent order in form N292, and Krishma is going to talk about that form in a little bit more detail in a moment. Second, details of whether liability is admitted or to what extent it is, the age and occupation, if any, of the child protected party, confirmation that the litigation friend approves the settlement. I've often seen that left out for some reasons unexplained, so they have to confirm that they're happy with the settlement figure, usually via a witness statement. Any relevant medical or financial or other expert reports. So in high value cases, you might have gone to an independent financial advisor. In almost all cases, you're going to have some sort of medical report, and it's to do with injuries. If it's a personal injury case arising from an accident, you have to set out the circumstances of the accident and detail the loss that's claimed. That's usually via a separate schedule. And then you have to attach any documents relevant to liability. And that would include anything relevant to criminal proceedings that have already happened or any inquest, and also details of any criminal conviction arising out of the accident circumstances. And then finally, a legal opinion, usually from counsel, doesn't have to be, but there has to be some form of opinion on the merits of settlement in most cases.
Just very briefly touching upon the draft consent order, so Form N292, that needs to be included as part of the claim form or attached to it. On this form, you need to fill out the party names and addresses for both parties. There is a header where you can insert each party's name and address, and you then need to go through the form, which sets out a number of provisions, and simply strike through on the form anything that isn't actually relevant to your claim.
Yeah, so there's all sorts of specific sections, fatal accidents, for example, which I'll come on to talk about in a moment, but there's bracketed sections that you just cross out if they don't apply to the type of claim that you're dealing with. So the need for a legal opinion, as I say, could be written by counsel or a solicitor. Most of the time, in cases that we've done, it's other junior barristers that are writing these opinions. They're needed in all but very clear cases, and although that's set out in Rule 21.10(3)(h), I have never seen a case where there hasn't been counsel's or solicitor's opinion. So in reality, you're always getting one. And you have to, and this is something that a lot of people overlook doing, you have to attach the solicitor's instructions to the barrister unless they're set out in the body of the opinion itself. So there are some special provisions that apply to certain types of cases. One is where future loss or periodical payments are being claimed. If you're claiming future financial loss, you have to record either in the body of the claim form or in the particulars of claim that you've considered whether periodical payments would be appropriate. That comes from Rule 21.10(4), and Krishma in a moment is going to talk through why one might apply for periodical payments rather than a lump sum. If the settlement does include periodical payments, the draft order has to comply with Rules 41.8 and 41.9. Now, 41.8 specifies what the order has to include. It's things like what the annual amount of the award is, how each payment is going to be made during the year, what the intervals of payment are, considerations if payments are going to continue after somebody's death for the benefit of their dependents. There are lots of things that are listed out in 41.8 that the order has to cover. And then 41.9 deals with continuity of payments. So when periodical payments are ordered, one of the things that the court will be concerned about is the party who's ordered to pay those payments likely to be able to satisfy that debt long term? And there are various ways that can be proven, and they're set out in 41.9. So if you do have a case where periodical payments are involved, look at those two sections of the CPR, make sure you've complied with them in the draft order.
And just on periodical payments, so they can be claimed in any claim with future loss, but realistically, they are generally only ordered in high value cases. One of the benefits of periodical payments is that they're index linked. And so they increase according to inflation, and they take into account any increase in, for example, carers' wages. They are often commonly used where a person's condition may be likely to deteriorate or improve, as the court can order that the payments increase or decrease at a certain date.
Okay. And another specific type of claim that has its own consequences and own things that you have to be wary of are fatal accident claims. So most commonly, you'll see these types of claims where you're acting for the dependent child whose parent or older relative is the deceased. If that's the case, you have to include in the claim form or the particulars of claim the loss of future earnings of the deceased and the nature and extent of the dependency. that effectively means how is that person entitled to the dependency? So, for example, by virtue of being the son or daughter of the deceased. And you should also specify whether there are other dependents that obviously would curtail the dependency of the person you're claiming on behalf of. And when you're filling out form N292, as I've said, there's a section relevant to fatal accidents, and you have to apportion the loss that's being recovered against the Law Reform Miscellaneous Provisions Act and the Fatal Accidents Act. Now, if you've settled for a global sum, that can be very difficult. The court has the discretion to make those decisions and effectively apportion it themselves under Rule 41.3a, but much the wiser decision if you are settling a fatal accident claim on behalf of a dependent child is to make sure that any settlement specifies what portions of the loss are attributed to which of the statutes and what type of loss, so that you can fill out this form really easily.
Because of course there may be many dependents in a fatal case, and again, in settling it, what sums are apportioned to which aspect of the claim needs to be thought about. It can't just be a global settlement, as Eleanor said.
Yeah. Okay. So, what actually happens at the hearing? This would be what happens if it's a Part 8 claim. So this is the process where you just need court approval for a settlement that you've already reached pre-issue. The defendant doesn't usually attend those hearings. It will ordinarily just be the claimant's barrister, the claimant, i.e. the child or protected party, and their litigation friend. One thing that so often it gets forgotten is that the child or protected party has to attend court with their original or a certified copy of their birth certificate. The order will not be made without it, and a lot of cases unfortunately just get adjourned because the litigation friend has forgotten it or hasn't been told to bring it. The most important thing for the hearing, other than filling out form N292, which we've already discussed, is completing form CFO 320. So it's the Court Funds Office form 320. Now, I've got a copy of that up in front of me. It's a multi-page form. Only the judge fills the last page, but whoever's representing the claimant has to fill out the first section. The first bit is just the details of the claimant and the details of the litigation friend. It's absolutely vital that the address, email, and telephone number set down in this form are correct, because otherwise the child is not going to get their money when they turn 18. It's only this form that tells the Court Funds Office how to contact the individual. And you need to let the litigation friend know that if they move addresses, they have to update the CFO. Then there's a second page which deals with how the award is invested, and Krishma is going to talk about investment in slightly more detail in a moment. But suffice to say, it's really important that the details in the CFO 320 are accurate. So once it's been filled out and you've taken it to court, make sure the litigation friend checks it over. It comes with an advice sheet, which has a little declaration on it that says that the litigation friend has had this explained to them. So at some point, either before the hearing or at the hearing, we routinely do it. We will explain to the litigation friend where this money goes and how it's invested and that sort of thing, as Krishma is going to come on to talk about. So just make sure that either you've explained that form to the litigation friend or you've asked counsel to do it. Then when you actually get into the hearing itself, the litigation friend will probably be asked to confirm that they approve of the settlement, but they will have already done that in writing with the claim form, usually by way of a witness statement. And then depending on the age of the child, the judge might sort of turn to them and ask them in a very sweet way, "Are you feeling better?" And they will hopefully say yes. it's really, really in a terrible situation if they suddenly say no and you're settling the case. And then the last issue, which is often one of the most contentious in these types of hearings, is justifying any costs or expenses to be paid out of the child's damages, and particularly any insurance premium. And we're going to come on to discuss that in a moment.
According to Part 21, applications for the approval of a settlement or compromise would normally be heard by a master or a district judge in proceedings involving a child, and a master, a designated civil judge, or his nominee in proceedings involving a protected party. And just very briefly touching upon the need to pay attention to the name on the birth certificate. I've had, and I don't know about you, but I've had a number of hearings where I've had to check that the name on the birth certificate does indeed match the claimant's name in terms of the proceedings. It's something that assists with payment out from the court funds office when the child reaches majority age. And quite often, if you notice, for example, that the child has got a middle name that isn't included in the court, in the name of the proceedings, you can quite often make an oral application to amend the child's name to that which matches the birth certificate with reservice dispensed with.
Yeah, that's a very fair point. So then you've got a slightly different scenario to consider where you haven't managed to agree a settlement at all. So you basically need to go to court and fight it out. In that case, you will issue under Part 7, like any other personal injury claim, that this approach also applies where you've settled one issue, but something is left to deal with. Usually, it'll be liability has been agreed, but you can't agree on quantum. If that's the case, you issue a Part 7 claim and then you make a Part 23 application within those proceedings to approve the liability settlement. Once that's done, the trial will just go on to quantum, but you still need to make an application for approval before the trial on quantum. If you're in a situation where you've issued the case and then it settles, and that might be the situation if, for example, you're running tight up against limitation and you just have to issue so that you don't prejudice the claimant's position, and then you get into settlement negotiations afterwards. In that case, you would again make a Part 23 application within the Part 7 proceedings for approval of the settlement. And those applications, if you need to make them, whether it's for approval of a liability settlement or approval for a later settlement agreement, you still have to include all of the things that are set out in Rule 21.103. So that's that big list of things you have to attach to the claim form. You still need to put that in. So what happens if you're dealing with Part 7 proceedings instead of Part 8? The defendant will come to these because they're contested hearings. The child and litigation friends still have to come with the birth certificate. They still have to fill out forms CFO 320, and the litigation friend must check that the details are correct. But unlike the Part 8 proceedings, where it's a very sort of gentle, almost sort of tick box exercise, it's a proper trial. So the court's going to hear evidence from both parties. They might need to hear evidence from the child themselves. There'll be specific applications for that to happen, but ordinarily the litigation friend will do it. If there's contested expert evidence, you'll have the experts attending as well. And then at the end of that, the judge will make a final determination on what the damages should be. And then they will fill out the last page of the CFO 320 in the same way that they would for an approval hearing under Part 8.
We're going to talk about the control of money now that is recovered by or on behalf of a child or a protected party. This is dealt with in Rule 21.11, which effectively it says that directions that are given may provide that the money shall be either wholly or partly paid into court and invested or otherwise dealt with. Now, where money is recovered by or on behalf of a protected party, or it's been paid on behalf of a protected party, the court will first consider whether the protected party is also a protected beneficiary. Where you've got a child that lacks capacity to manage and control any money that's recovered either by or on behalf of the child and is likely to remain so on reaching majority, the fund will be administered as a protected beneficiaries fund. It's worth also noting that within that rule, it states that if a child or protected beneficiary is in receipt of publicly funded services, that the fund shall be subject to a first charge under Section 25 of the Legal Aid Sentencing and Punishment of Offenders Act 2012, and an order for investment of the money must also contain a direction to that effect. Now, in circumstances where money is recovered for the benefit of a child that is not a protected beneficiary, the court may order that the money is directly paid, for example, into a bank or building society or similar account for the child's use. And if the money does remain in court, it must be paid out to the child when the child attains the age of 18. Again, in the circumstances where there are any investments that are held in court, other than money, those investments must be sold and the funds also transferred to the child upon the child reaching majority. Now, where money is recovered for a protected beneficiary, if the sum is greater than £100,000 or more, in that situation, the court will direct the litigation friend to apply to the Court of Protection to appoint a deputy, after which the fund will be dealt with as directed by the Court of Protection. At the hearing of an application for the approval of a settlement or compromise, if the compromise is indeed approved, the court may then proceed to give investment directions that relate to the damages recovered. And again, as I've said in the first sort of bullet point there, it's Rule 21.11.1 that says that money recovered by a child will be dealt with in accordance with directions that are given by the court. There is also a situation where the judge may not proceed to give investment directions immediately following approval of the compromise. And if that does apply, then a separate investment direction hearing will also be listed.
And that tends to apply to more complicated cases where you're usually dealing with advice from an independent financial advisor and it's more of an involved issue. If you're going for a fairly low sum of money, judges will ordinarily direct that it is dealt with in that infant settlement hearing. So where does the money go? Either it goes into the special account, which is a highly protected government bank account, effectively, where it earns a really meagre rate of interest, but at least it's very safe and it stays there until they're 18. Or if they're taking more than £10,000 from the defendant and they've got more than 5 years left until they turn 18, a percentage of the funds can be placed in the equity index tracker fund, which is a slightly more risky but high yield way of the government investing it. Both of those are effectively run by the Court Funds Office, so they are separate to payments that would be made to a child's trust fund or ISA. As Krishma's already covered, those payments can be made provided it's a child who is not a protected beneficiary, and provided the litigation friend comes to the hearing with sufficient evidence of a secure bank account or ISA that can't be touched until the child is 18. So that's a really important aspect of it. Lots of parents will say, oh, I've got a junior ISA, it's going to earn better interest there than it will in the special account. Absolutely fine, that's probably right, but they have to come to the hearing with a printout from Halifax or Lloyd's or whoever it is, with the terms and conditions that relate to the trust, so that the court can see that they can't access the funds until they're 18 and that it's going to be safe in there. They also need to know the actual account details, so the sort code and account number, which I've had in circumstances where we've come with everything except for that, and then they can't make an order that it goes in there. If the money is invested in court, it's then paid out to the child when they reach 18. The investment, other than money, is a reference to funds placed in the equity index tracker fund. So if you see any references to investment other than money, that's what's meant by that. There are two other common types of investments in children cases. One is payment into a personal injury trust. Those tend to apply where we're talking about really quite large sums, especially if they need regular access to the money for regular outgoings and expenses relating to sort of accident, disability or anything like that. And Rule 21.11.8 specifically provides that that the court can order that the funds are paid into a bank account or building society account, as I've covered. So that tends to be more where the sum is small.
Or, as an alternative, the funds could be placed into a trust for the child. Now, if a fund is paid into a trust following judgment, it must be a bare trust. The court does not have power under Rule 21.11 to order or impose a discretionary trust on such monies. And remember, bare trusts are often used to pass assets on to young people, and the trustees will look after them until the beneficiary is old enough. The court's powers are restricted to facilitating a bare trust, which is essentially administrative in nature. But the court can, it's worth noting, approve the establishment of a discretionary trust. Now, in the event that if the fund is paid into a bare trust, the child is entitled to call for the fund to be paid out to them upon their majority, but the child would also have the option to leave the fund in the trust.
So those are all things that apply to child cases, and the rules are slightly different for protected beneficiary cases. So the rule 21.11.9 deals with where the money goes if you've got a protected party rather than a child. The Court of Protection deals with sums of damages of £100,000 or more. So if you're dealing with 100k plus, it goes to them, they appoint a deputy, their procedure and rules apply. If you're dealing with something below that threshold, then rules 21.11.9 C and D are assumed to apply. The funds will be retained in court and invested in the same way as they would with a child. So all of the same considerations that we've just discussed would apply if you've got a protected party and the award is under £100,000.
Moving on to costs and expenses incurred by litigation friends. So this is set out in 21.12. And this rule allows the litigation friend who has incurred legal costs and expenses on behalf of the child or protected party to recover that amount paid out of the child or protected party's damages. Now, the application can only be made in respect of certain costs and expenses, and there is a general restriction that the amount must have been reasonably incurred and reasonable in amount. Payment out of legal costs can be claimed where the costs have been subject to detailed assessment or where detailed assessment has been dispensed with. The costs incurred by way of a success fee under a CFA or damages-based agreement can be recovered in a claim for personal injuries where the damages agreed or ordered to be paid don't exceed £25,000 and where the costs have been summarily assessed. The expenses that may be claimed may include ATE premiums or interests on a loan that is taken out to pay for such a premium. Now, rules 21.12 subsection 7 and subsection 8 restrict the amount that can be claimed in cases where the amount paid to the child or protected party does not exceed £5,000.
Now, we have had many cases where the most fraught issue is justifying these ATE premiums, and perhaps it's sensible just to say a little bit about that now. The court is not going to order money to be paid out of a child's damages unless there is really good evidence that this is a high-risk case and it was justified to take out an ATE insurance policy where payment of the premium has to come from the child's damages. What that means in practice is that the court is going to need to see a risk assessment conducted by the solicitors where they set out the specific reasons why this is a high-risk case. You're not going to be able to justify it in cases where you've got liability admitted, or you've got claimants who are clearly never going to be found to be at fault, or who clearly on any sort of arguable view could not be at fault. So the types of cases where you are in fact allowed to take money out of the child's damages to pay an ATE insurance policy are quite limited, and Krishma's going to go on to talk about that a little more in a moment. Suffice to say, these rules don't necessarily apply if fixed costs apply. So under Rule 21.12(9), if this is a fixed cost case, either under Section 4 or 6 or 8 of Part 45, and no application has been made to disapply the fixed costs regime, then payment out of the child's damages can be ordered for those fixed costs. Otherwise, you can't have any payment out of the child's damages until there has been a detailed assessment of the costs, or they've been agreed. And in reality, most of the time, costs are agreed behind the scenes once the order is obtained.
Just moving on to part 2 of this slide. So where a claim is settled or compromised or judgment is given for less than £5,000, the total amount that the litigation friend may recover must not exceed 25% of the damages agreed or awarded in respect of both general and special damages. And that's set out in 21.12 subsection 7. If there is an application for costs and expenses, there are a number of things that must be included by way of a witness statement and exhibits, which Eleanor will now take you through.
So the nature and the amount of the costs and the reason why they were incurred, a copy of any conditional fee agreement or damages-based agreement, a risk assessment, which is what I've referred to already, by reference to which any success fee was determined and the reasons why any particular funding model was selected. The advice given to the litigation friend on funding arrangements. This information is not privileged. The court is required to see it, or the court requires parties to divulge it. A copy bill or an informal breakdown of the solicitor and client base costs incurred. Details of any costs agreed or recovered or fixed costs recoverable by the child. An explanation of the amount agreed or awarded for general damages and also for past financial losses, net of any sums payable to CREW or the DWP.
Now that witness statement and the associated exhibits in terms of that list are really, really important if an application for payment out is going to be successful. I've had, and I'm sure you've had, a number of cases where one or more of those items wasn't addressed, and therefore it resulted in the court not approving an application for payment out. I've had a number of cases where, for example, a risk assessment is left, it's included, but it's left blank.
Yeah.
And it's deemed not to comply, and therefore a payment out is not approved. I've also had a couple of cases, and this is something that Eleanor talked about earlier, where the risk assessment concluded that the risk was too high. So, for instance, the court has considered that the level of risk that's been assessed is actually not proportionate to the level of risk that in fact exists in the case. So, for example, I've had a case in the past before where the litigation friend was seeking a payment of costs out of damages, where there was a risk assessment that concluded that there was a risk, 100% risk in terms of running the claim, and therefore the upper limit of 25% of the damages were sought. When we got to the hearing, the judge noted that the circumstances of that case included that the child was a backseat passenger in a parked vehicle that was stationary at the time and in circumstances where the defendant had admitted liability. Now, in that case, the judge considered that the risk assessment should have resulted in a success fee of 5% and not 25%, and therefore limited it to 5%. And so it is really important to give some serious thought to a risk assessment and considering really how that would be dealt with at a hearing, because of course it's got to be justified by counsel at the hearing.
Yeah. And finally, our last slide. If you want to discontinue this type of claim, you can do. You don't need court approval to do so, but a word of warning. if in discontinuing you are effectively following through on an agreement with the defendant to do so, i.e. you have said to them, it's a drop hands type situation, we'll both walk away, court approval is required because the court still needs to be able to regulate decisions made on behalf of children to give up their cases in circumstances where their solicitor has been negotiating with the other side. So if that's the case, Sayers and Smith Klein Beecham says you have to get court approval. Again, you do that effectively using the easier Part 8 proceedings. If it's just but you'd have to go through the standard Part 7 process and then make a Part 23 application within those proceedings. And that brings us at 18:02 to the end of our talk. So I mean, we might have time for a couple of questions, but I think we won't keep you too long. So we'll just have a quick look.
I think that's a question that needs slightly longer in terms of an answer.
Yeah, okay. We've had a very interesting question through from one individual, and we can respond by email. It's probably going to be quite involved. Otherwise, I don't think there are any questions that anybody else has sent in. So we'll say thank you so much for joining. And we hope you found it interesting. Yeah, we'll follow up with any unanswered questions by email. Feel free to send emails to events@42br.com, and the recording and these slides will be available shortly. Do feel free to drop any feedback off when you are sent the email with the recording and the slides. It really is helpful. And otherwise, thank you very much for listening, and we'll wish you all good night.
Hope it's been helpful to listen to us, and thank you very much for joining us. Good evening.
Thanks.